Hello everybody, I am Holly Brewster. I'm an associate solicitor in the dispute resolution, employment and immigration team. I work closely with Patricia and with Jill as well on various aspects. I just want to really talk about a number of things that are emerging from the pandemic. It's been a rocky road for businesses, as we all know, and it's going to continue to be so. We're expecting, us lawyers, that there's going to be quite an increase in businesses experiencing difficulties or needing to restructure or just really managing their exit from the COVID situation and the protections that the government has had in place so far. It's a good idea to start thinking about these things now. I mean, furlough, for example, we know has been extended again until the end of September 2021. Which is, I'm sure, a very welcome development for everybody. However, it is tapering off. And from March, a couple of months ago, I'm sure you know, employers are expected to contribute 10% extra towards those salary payments of their employees. And as of July, that will rise to 20%. Now, this applies just the same to sponsored employees as to domestic employees. So you've probably already been paying furloughed employees if you have any up to now, but that will continue. And there's absolutely no difference in treatment whatsoever. If they qualify for furlough, they're entitled to receive those government payments. So make sure you make the most of those. Supporting your business through COVID. Now, Patricia's already spoken about this. This is in relation to your sponsored employees. While usually there are great limitations on this aspect of your sponsored employees' employment, and it's all very dependent on what it says in your SOC. At the moment, as Patricia's already said, you can extend unpaid leave for a full-time sponsored worker rather than only being able to take up to 4 weeks unpaid leave per year. It's now unlimited as long as it's related to COVID and restructuring, and as long as it is applied across the board. The main takeaway is that you have to keep records of all absences and reasons for absences. It's very important to make sure that you have those HR files evidencing all of this, so that after the end of these measures, you can evidence anything to the Home Office that you need to. The same goes for a reduction in the sponsored workers' hours of work or pay. Again, any reductions in pay must be part of a firm-wide policy designed to avoid the need for redundancy. So it's not just a question of being able to cut your sponsored employees' pay willy-nilly, but if it's part of a scheme and it's designed to help your business weather the storm of COVID, then that's perfectly acceptable at the moment. It doesn't change the visa or any documentation. Again, just keep records of it. And again, changing the sponsored worker's job, this is slightly more complicated because you still need to be within the COS. But the difference here is that if you do want to slightly rejig your sponsored workers' duties during the COVID pandemic, if it's not within the same categories on your certificate of sponsorship, you do need to apply to amend that. However, normally you have to wait until you've had your application accepted from the Home Office before the employee can start in the new role. That is not the case at the moment. So while we're still in the COVID time, you're able to have the worker, the sponsored worker, working in that new role or that slightly different role pending the outcome of the application. So as soon as you want to change that worker's job description to help through the pandemic, you can do that as long as the application is in.